My name is Janet Battey. I am a partner at Ferro and Battey. We are located in Darien, Connecticut. Actually, our neighbors are HAYVN next door. And we practice at our firm exclusively matrimonial and family law. So this is the subject of what we do on a daily basis. The topic today is navigating the divorce in a post-COVID world. And one of the major changes that have occurred with regard to divorce in Connecticut is that the judicial system has changed the way it handles dissolution of marriage cases and any type of post-judgment cases in terms of the management of the case and the flow of the case in the system. So the judicial branch had worked to come up with a different case management system, which was then put kind of fast-tracked as a result of COVID. So what we have now is a new track method for cases. And what that means is that when a case is filed, what the court now does is schedule something called a resolution plan date. And that's usually within 30 to 60 days of the filing of a case. And what that resolution plan date is a date where you, your spouse and your attorneys, or your ex-spouse if it's a post-judgment motion, or your child's other parent if it's a custodial action, go into court and meet with family services. Family services is a division of the judicial branch. There are social workers who help people work on agreements. And in that meeting, you'll talk about your case, you'll talk about the issues in your case, you'll see if you can come up with any agreements, especially with regard to parenting, if there are any minor children. And then the court will, or the family services officer will assign your case to a track. So there's now track A, track B, and track C cases. So track A cases are cases that are pretty much resolved or close to being resolved. Usually often there's no children, there's no custodial issues, there's not really any financial issues. And the court pretty much in those cases just sets them down for some kind of a follow-up conference, but there aren't any hearing dates or anything like that assigned to those cases. Track B is the bucket that most cases fall into. Those are kind of middle of the road in terms of conflict as far as the court sees it. There may be discovery issues, there may be some pending support issues, or things of that nature, or maybe some parenting issues that the court sees on the horizon, but they're not considered to be the kind of the highest conflict cases. So those cases are assigned to track B, and the court generally will schedule what are called case dates, which are hearing dates, and they'll schedule 1 or 2 hearing dates for your case, depending on what's necessary, and then as well as pretrial and trial dates. And the court's goal is to try to get those cases resolved within 9 months to a year. The last track are track C cases. Those are considered to be high conflict cases. They're usually highly disputed custody cases, or if there are significant financial issues such as valuation issues, issues regarding premarital agreements, things of that nature, where the court thinks that they're going to be quite high conflict. Those are scheduled, those are categorized as a track C case, and those cases are given more follow-ups with family services, more hearing dates, and the time in which trial is expected is a bit longer. What does it mean? It means if you're involved in the system before, you're kind of now on this new track where if you file motions or things of that nature, you're going to be, for the most part, unless it's some kind of emergency, waiting for one of your case dates to occur. You can file a case flow request asking for an earlier hearing date, but for the most part, there's kind of already this preordained schedule that your case is going to be following. Whereas if you're involved in the judicial system in the past, we would file a motion and have it appear on a short calendar within a matter of weeks. So what that means for our clients or for cases that are being filed is that there needs to be a bit more in the way of planning that goes into the motions that are going to get filed, how they're going to be heard, and what can be done to try to mitigate the need for some of the court intervention on an immediate basis, because short of emergency motions, which still exists, and restraining order motions, it does take longer to get kind of a more general motion heard before the court under this new system. So for example, in terms of support, you can't file a motion and get into court in 3 weeks, whereas you may have been able to do that in the past, unless they're really dire circumstances. So you want to have a conversation even before a case is filed, if you can, surrounding with your lawyer about how our bill's going to be paid, or what can I do to kind of protect myself in these different scenarios. Same with regard to custodial issues. If there are things that need to be discussed before the action is filed, problems that you anticipate coming up, so you can come up with a strategy of how to have those best heard by the court, because you really want to be able to raise any issues that you think are going to come up right away in the case, so that they're before the court before the resolution plan date, or you have the information you need to try to push the issue with the court. So it does require a bit more strategizing than the old system, where you would file a motion, file the action, file whatever motions you needed, and then they'd come up with a short calendar, and you'd go from there. The other major difference has been, obviously, a lot of things were moved virtually during COVID. In fact, almost all the hearings and trials at one point in time were held virtually, as well as status conferences and pretrials. The court has now moved back away from that. Most hearings and trials are done in person at this point in time, and status conferences, some are in person, some are not. Pretrials, similarly, some are in person, some are not. The court is cognizant that some people are still wary of COVID, and if a party requests that something be heard virtually, you can file a case flow request with the court, and depending on whether the other side objects and what the reasons are, the court may or may not grant a virtual hearing. It's a little bit more difficult in terms of timing for virtual events, because the court's a bit more limited with the technology, but if there is a sensitivity to that, that is something that can be handled. Those are pretty much the major changes with the process itself. Starting a case is still the same. It hasn't changed motions or anything like that, but it just has changed the process of how a divorce is handled. So it's important to speak with someone and get the process, have an understanding of the process, because if you're talking to someone who got divorced a few years ago, the process is going to be very different now than it was in the past. So that's probably the biggest change that's happened as a result of COVID. And now Olivia from my office is going to talk to you guys about some of the more practical substantive changes in terms of issues that we're seeing before the court, that are not procedural, but actually kind of substantive issues that we're seeing as a result of COVID. So Olivia Eucalitto works at my office. She's an associate here, and I'll turn it over to her.
Thank you, Janet, and thank you to everybody for joining us today. As Janet said, I'm going to talk a little bit about the substantive issues that we're seeing as a result of COVID, and I'm going to talk first about some of the parenting issues that we're seeing. There's a lot of gray issues, and I think it all kind of depends on your and your family's approach to COVID, but we're seeing issues related to vaccination of children, masking of children, issues related to vacations, right? So before COVID, you had maybe a parenting plan or could reach some kind of agreement or some order about when you were going to travel with the kids, how that was going to occur. And just generally, are we getting on planes? Are we doing this? Are we doing that? But obviously travel has been a bit more complicated as a result of COVID, and may require testing, quarantining. So planning family vacations or traveling with the kids has become more of an issue for families. And then kind of incident to that, makeup time with parenting, because if people are quarantining as a result of COVID or traveling or things of that nature, what kind of other additional time is the other party entitled to? And then we're kind of seeing, when one person gets COVID, or when the children in particular get COVID, should they still be going back and forth between the kids or the parents' houses? How does that all work? There's no uniform way to address all of these issues. It's really a fact-specific, problem, and related to the family in particular. Does someone have health issues that we need to be aware of? What does the children's school require in terms of quarantining? Or what are they asking for in terms of testing? There's no real right or wrong answer to a lot of these issues, but they are coming up and they are requiring a lot more flexibility and a lot more attempts by the parents to try and resolve these issues between themselves, because as Janet kind of alluded to, it's much harder to get into court. So if you do have an issue about makeup time or vacations or that kind of thing, it's really in your best interest to try to resolve that with the other person, because it is harder to get into court. That being said, there's ways to address emergency issues with the court as it relates to your children. If you believe there's an immediate and present risk of physical danger or psychological harm, that would warrant an emergency motion, and the court is required to have a hearing on that issue in 14 days. So that's one way to kind of fast track the issue and get before the court if you're unable to resolve it. On a separate note, we're seeing additional or kind of a new issue related to more people working from home, and what does that look like in terms of custody orders and parenting plans. People are generally more available than they were, right? So pre-COVID, you had a number of people commuting long hours into the city or working at an office. Obviously, that's all changed and people have, I think, more flexible schedule. Does that warrant a change in the parenting schedule? Does that mean that parents more available for their children? Is the office going to require that parent to come back in 2 months, meaning that it's kind of pointless to change the parenting schedule at this time? Those are all issues that we're seeing and we're trying to deal with, and certainly issues that really didn't occur at all before COVID. And then finally, the last bucket of changes and new issues that we're seeing relate to where people are currently living, housing availability, and also selling of the marital home. So certainly everybody knows that the market is super hot right now. If you have any desire to sell your house, obviously now is the time. The issue becomes that during a divorce, you're unable to sell your house unless the other party agrees in writing. So if one person doesn't want to sell and you're getting divorced, there's nothing you can do. So if there's any way, that you and your spouse, before you get divorced, can figure that out, or, if you can try and do that before you get divorced, that would be better, because once the divorce starts and if one person decides, hey, I no longer want to do this, there's not much you can do. And then the other problem we're seeing somewhat related to that is just there's not a lot on the market in terms of rentals and available housing. So, if you're in the middle of the divorce and you're trying to separate and move out, it's a little bit harder, or quite honestly, much harder, just because there's things that are going, or houses that are going so fast, rentals that are going so fast. It's a bit more challenging than it was pre-COVID. So at this point, I'm going to turn it over to Phyllis, and she's going to talk about the psychological aspects of this topic. Thank you.
Hi, everyone. Thank you to Janet and to Olivia and to Megan, really, for organizing this as well. I'm really happy to be here with all of you. So I'm a psychotherapist, and I have a private practice here in Darien. I'm also part of the Divorce Club. So I've actually been through the process many, many years ago. And given what Janet was saying, yeah, the court situation is very different than what I went through. So in terms of COVID, it's no secret that we have seen an explosion of mental health issues, particularly in the realm of relationships. We're seeing high conflict, divorces really coming out of this. We're seeing increase in substance abuse, increase in domestic violence, which those numbers are sort of off the chart. And we know that our children are really suffering. We don't have to talk about, but I will mention, the tragedies that have happened here in Darien. And recently, the community fund in their, I think it's the health, they do like a survey every year to talk about sort of mental health issues. 46% of all Darien high school kids report symptoms of anxiety and depression, and 30% of 7th graders report feeling stressed. Now that's just pandemic. And now we're going to throw on top of that sort of if a child and parents are divorcing through the pandemic. So let's just, kind of add much more intensity of issues on sort of the family system at the time. So it's really, really important to understand a couple things. One is that 50%, this is from the APA, American Psychological Association, 50% of all children will experience psychological symptoms from divorce within the first year of divorce. And those symptoms look like anger, irritability, sadness, perhaps increase or exploration of substance issues, being very clingy, fearful, some behavioral issues, and some school issues. So just know that 50% of our kids who are going through divorce will experience this within the first year. And then let's just add on COVID. So what is our role as parents sort of, and as providers sort of in this scenario, is to be very, very, very keen and sensitive to the fact that we can almost expect our children to have some mental health issues because it's a trauma, what they're going through. The breakup of a family is a trauma. So our role is to really recognize this, get out ahead of it, acknowledge it, and be incredibly supportive. So what's our role during COVID been? We're more home, we're more available, we're working from home, we see things more. So the things that I would sort of share is what we're seeing is, because both parents are home and if they're going back and forth, there is more touch points that didn't always exist. So COVID in that arena has been really good. Whether it's by Zoom, parents are seeing each other or, through a little, maybe COVID has prevented some contact, but I think we've all experienced greater touch points with one another in terms of the family system. Be that as it may, if it's a high conflict divorce and we're worried about partners and safety issues, again, that's obviously something you're going to work through with your lawyer. But at the same time, I'm really encouraging everyone listening to this is if you don't have a mental health person helping you or your children, please get one. It's important to kind of have a great framework and how to navigate psychologically through this. It gets really easy to get wrapped up in a lot of issues here that we ourselves are going through divorce. And again, emotionally, we're going through a lot because of COVID too. We've suffered a lot in terms of not a lot of contact with friends, feeling very isolated. So I guess my really big message is to recognize that the pandemic has just increased the stress and has created a lot of emotional dysregulation for all of us. But those of us going through and families going through divorce really need extra tender, loving care, is sort of how I would frame it. Little bit to what Olivia was saying, just some sort of tips in going through this is to just, recognize that, kids need support, their own support. What I'm noticing sometimes with divorce situations, the conflict can be if one parent doesn't want another, if the parents aren't in agreement that the child could use some support, that can get a little dicey because a therapist would need a release from both parents. So if you are in the middle or thinking about divorce, is just getting out ahead of mental health issues and getting some agreement around it. Because it gets really complicated if there isn't consent from both parents in terms of, kind of how to navigate and then really talk about what issues are impacting your child. So I would sort of, think about that in terms of what you may need going forward, or put that into your agreement, or begin talking about that with your ex-spouse, and recognizing that even though you have terminated your emotional and intimate relationship, you're still parents of this family, and that if you're aligned in what's best for the children and best for your family, that's going to go such a long way in terms of your divorce proceedings, your outcome, and sort of your future co-parenting, and sort of the health and wellness of your children. I could talk about many subjects here, and happy to answer many questions. But I think that's what I'll share for now, but happy to go on. Thank you.
Does anyone have any questions? Phyllis, that was great. Janet and Olivia, so informative. And now I just posted in the chat to see if anyone has any questions. And if you want to write them in the Q&A, Janet, Olivia, and Phyllis would be happy to answer anything. It's okay to not have any questions too. See if anyone has any.
We have one.
Okay, we have one, let's see. It says starting from no knowledge. Is this process straightforward about dividing property? I think that's Janet or Olivia.
Sure. So it really depends on the case. The court, obviously one of the things that the court has the inherent authority to do is divide property at the time of the divorce. So in order to get divorced, both parties have to file financial affidavits with the court, which is a full disclosure of your income, assets, expenses, and liabilities. And part of there's at the end of the case, the court divides the assets. Kind of how you get to the end of the case is the part that can be either straightforward or not. So if you and your spouse are in agreement as to how the assets are to be divided, or at any point in time become in agreement, what you do is draft what's called the separation agreement, and the court will enter your agreement as an order, and that will be how the assets are divided. The other option is obviously if you and your spouse can't agree, at the end of your case, there's a trial and the court decides how the assets are divided. Now, that only happens in about 5% of cases. 95% of cases may involve some litigation, but don't actually end in a trial to divide the assets. There's a statute in Connecticut that lists the 16 factors the court should consider in dividing assets at the time of the final trial. Those are factors such as each party's contribution to the assets, the earning, the potential assets to be acquired by a party in the future, each party's station in life. So there's a variety of factors that go into that. After you look at those factors, though, it's in the discretion of the court. So we are not a community property state. We are an equitable distribution state, which means what the court deems to be fair and equitable is how the assets are divided, or what the parties deem to be fair. And then the court will stamp its, seal of approval that it's fair and equitable. So it really is dependent on each person's personal situation. Were there premarital assets? Is there a business or some type of asset that needs to be valued? Is there inheritance that needs to be considered? Is the earnings of one party something that needs to be considered in the division of property, or certainly in the payment of alimony and child support? So in some cases it is really straightforward. In other cases it's not straightforward, or as straightforward, I should say, and there's room for debate. So it really depends. It is situation dependent.
I think that was a good answer to a tricky subject. Anything else, guys? Thank you so much for joining today. We hope that this was informative, and you can always reach out to Phyllis or Janet or Olivia. I'm sure there will be like a follow-up email, and with all their contact information will be sent to the attendees.
I think there's another question. Did you see this? By Kristen, the movie version is at one.
I think it was just sort of saying,
it's a comment.
So to answer, I guess, sort of that, one of the factors that the court can consider at the time, or is supposed to consider at the time of dividing assets, is fault for the breakdown of the marriage. So there, Connecticut, while people will say we are a no fault state, that means you do not have to prove that someone is at fault in order to get your marriage dissolved. Most marriages are dissolved on the basis of that the marriage is broken down irretrievably with no hope of reconciliation. However, even if that's the basis on which your marriage is dissolved, the court can still assess fault in dividing assets and awarding permanent alimony. So that is where you get into, did someone have an affair? Does someone have an addiction issue? And, was someone not fully transparent about assets or what they were doing with money, things of that nature. So that's where the fault claims come in, and those can come in any case. There is often a lot of debate back and forth, and it may not have an effect, or it can have an effect on how the court divides assets, depending on what the court sees as the severity of it, the effect that it had on the other party, the effect it may have in the future, things of that nature. So there is an element of that. It is one of the factors which sets Connecticut apart a little bit from some other states. So we are a no fault state, but the court is to consider fault in making its decision.
I think that's it for now. Thank you guys for joining today. We really appreciate it. And we hope you feel a little bit more informed.